point out is this is one piece of regulation that very directly talks of objectionable advertisements. So the name itself suggests that certain advertisements will be objectionable if they fall under the purview of the definitions given under the Act. And those advertisements which are objectionable could be relating to a drug or a magical remedy. So I'm not going to go to the definitions, but they have been specifically defined as what is a drug and what is a magical remedy. And these are the possibilities where it will be held to be objectionable. So any drug for the treatment of certain diseases and disorders which are specifically prohibited under Section 3, and I've given you some. Now, in addition to these three, which are relating to miscarriage, correction of menstrual disorder, improvement for capacity for human beings for sexual pleasure, there is one whole list which is given in the schedule of that legislation. So if the drug falls under the list, under one of the items in the list, then the compliance of this law, there is any non-compliance of the DMRA or the DCA, there is direct criminal prosecution with an imprisonment up to 6 months. And it is very specifically written that in case of a company, the board or the person who was in charge of running the business will be liable for criminal prosecution. So generally when we say, but it's, it's a separate legal entity, the corporate veil cannot be lifted and people who are running the company cannot be made liable for criminal prosecution. But there is an enabling provision in the Act which says the board and the persons in charge of running the business will be made liable in their capacity as per their designation for criminal prosecution. Wide powers have been given to the police for search and seizure, and the place where the drugs are stored, or where, in our case, where the advertisements were even created or made, there could be a search, not only a physical search, but there could be search on digital assets as well. So your computers, your networks, your phones, all will be exposed to a search and perhaps even a seizure. The IMC regulations again are very, very simple to understand because they're very direct. And the only thing that one needs to remember is, are we dealing with these two entities as two separate entities? A medical practitioner who has nothing to do with what the pharma company is doing, his job is to prescribe medicines the way he has been trained to do, irrespective of from which company it is coming from. And that is exactly what is expected of a pharma company. Do not influence the doctors to prescribe your medicine, irrespective of whether you're good or bad, because that's not his job. So you don't interfere with his professional autonomy, is what the professional code of conduct is trying to say. But obviously it didn't happen that way, and that is why it had to undergo again a very large amendment which said that pharma companies cannot do this, cannot give gifts, and cannot sponsor or cannot give any monetary consideration to the doctors. Otherwise that would be frowned upon even by the professional bodies. Very easy to understand. For any Ayush medicine, no advertisements unless there is an advance approval by the state licensing authority, and every ad will have a unique number. So that is what, these are the two compliances which are an absolute essential. Sure, there are some things you don't like me saying, but I have to. Such orders had to be even thought of. This has not been passed as yet, but it could come in any time, or maybe UCPNP will get converted into a full-fledged legislation. But three very stringent consequences were prescribed under that order. One is a criminal prosecution, which I've already talked about, monetary compensation or a liability or payment of penalty, and suspension of the marketing activity of the highest selling drug of that company for a specific period of time were the prescribed penalties under that order.